Recently, President Biden signed the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act of 2021. This piece of legislation, I don't necessarily want to say surprisingly slipped through, but was a relatively rare bipartisan piece of legislation that got to the president's desk these days, and he obviously signed it. What this law does is invalidate these types of pre-dispute arbitration agreements with respect to sexual assault and sexual harassment claims. So especially in the workplace, the sexual harassment claims under Title VII and or under state laws like the New York Human Rights Law now are not subject to pre-dispute arbitration agreements. In other words, if you have the employee say any disputes arising during employment will be subject to arbitration, that could not be enforced as to sexual harassment claims. It likely could still be enforced as to any other types of claims. And it's not clear that you have to specifically carve out sexual harassment claims when you write those arbitration agreements, but clearly, as an amendment to the Federal Arbitration Act, this law is now going to give employees the right not to arbitrate their sexual harassment claims. Of course, if they want to agree to do so, they certainly may, but they can't be compelled to do so. It does not address any other forms of employment discrimination, including just sex-based discrimination. For example, someone claiming that they were not hired and a male was hired and they feel that that was a sex-based decision, that would not be prohibited from arbitration. Now, in that case, if someone wasn't hired, they may not have signed such an arbitration agreement, but let's say it was more like a promotion situation, then that could be an issue. Now, if you remember, I mentioned that New York had anti-arbitration statutes that the courts have not most often enforced. This seems likely to affect the enforcement potentially in two ways. One, it is now clear that you're not going to be able to enforce these provisions in sexual harassment cases. But as to other forms of employment discrimination, I think this may only strengthen the argument that New York's law can't prohibit enforcement of arbitration agreements outside of sexual harassment claims, because the carve out at the federal level is clearly specific to sexual harassment claims, in effect indicating that it's still clearly the federal law that any non-sexual harassment claims can be subject to pre-dispute arbitration agreements, and as federal law that preempts the New York state laws. So I'm not a judge and I can't guarantee that that's going to be the outcome, but that is what I predict this will mean in New York at this point. Whether in the future Congress extends this ban beyond sexual harassment to other forms of employment discrimination, I can't say, but that remains a possibility and we will just have to wait and see.